Okay, good morning. We're back to MiFID this morning and to the group presentations. We have um, three presentations scheduled for today. Um, so let me just check the name of the groups. Yes, we have, two presentations this morning. We have group number 9 and group number 10. Okay, so I will start by presenting these slides on conflicts of interest. Then I will stop for a few minutes and give the way to group number 9 and then to group number 10. Since it's two groups, the groups need 15 minutes each, so it's half an hour. I think that I will speak for 20 minutes and then I will stop, leave the room to the first group, and then for another 20 minutes and leave the room to the second group. Okay, so conflicts of interest is the last topic that we are looking at in relation to MiFID and conduct of business rules, together with the suitability and appropriateness, best execution, product governance. It is one of the core topics of investor protection under MiFID. Keep in mind that you have these big topics that you need to be familiar with: the suitability and appropriateness, best execution, conflicts of interest, and product governance. And even if there are many other rules on investor protection in MiFID II, this is really the core part of the directive that you need to be familiar with. Now, conflicts of interest is a traditional topic of investment services regulation. It has been one of the core topics since the ISD directive of 1993. And in the world of investment services, conflicts of interest are pretty common, and they are difficult to eradicate or to eliminate. They are sort of embedded in the, first of all, in the fiduciary duty that the investment firm owes towards the client, but they are also a consequence of the multifunctionality of investment services and investment firms. By multifunctionality, I mean that the approach that MiFID has to investment services is clearly that of the multiple provision of services within a single legal entity. The list of investment services that we discussed is quite long. It's quite comprehensive. You remember that from MiFID I to MiFID II, the list has been integrated and has become longer. So the range of services and activities that an investment firm can provide to the client is quite staggering. And conflicts of interest, when you amplify the range of services that can be provided, obviously conflicts of interest are more common. Also, you should consider that credit institutions fall under the MiFID regime. And for credit institutions, the problem is even higher or more complex, because you have the contemporary provision of banking services, such as typically granting of credit, and on the other side, investment services. So there have been over time big discussions as to the approach that regulation should adopt vis-a-vis conflicts of interest, and it soon became clear that in this area, conflicts of interest cannot be entirely avoided or exacerbated, and because they are really embedded in the structure of the provision of these services. So it is more advisable to try and regulate these conflicts of interest so as to reduce the risk of clients being damaged by conflicts of interest, rather than by taking what might seem as the best solution, saying conflicts of interest must be exacerbated, but must be excluded. They have to be entirely prohibited. This approach would not work, because the way in which MiFID is construed gives way to inevitable conflicts of interest. So you have to be more reasonable and more close to reality, and rather approach this topic by saying conflicts of interest must be handled so as to reduce or eliminate the risk of clients being damaged. There may be loads of conflicts of interest involved in the provision of investment services, and you can, the traditional approach, the one that MiFID takes under Article 23, is to distinguish among conflicts that arise between the firm and the client, or that conflicts that arise among clients themselves. Let me make an example of the first kind. A conflict between an investment firm and the client is a situation where the behavior, the conduct of the firm is biased because it is sort of making the interest of the firm prevail vis-a-vis the interest of the client. Example, think about a bank that provides credit facilities on the one side, and the other side provides investment services. Under the investment services activity, it places securities of issuers on the market. And on the banking side, it grants credit to corporations and enterprises. A typical situation of conflict would be that whereby the bank is exposed towards an enterprise because it has granted credit, significant amount of credit to a certain enterprise, and at the same time it is placing securities issued by that enterprise on the market. So what might happen is that the way through which the securities are distributed may pave the way to conflicts of interest, whereby the securities are sold to investors that do not have the appropriate suitability or appropriateness profile, and the placement of that security is strongly pushed forward in order to collect the money that the enterprise would use in order to reimburse the credit facility. And in this situation, there may be distortions on the way through which distribution takes place. The bank has a strong interest in placing those securities, not just because it is providing the investment service, but because by placing those securities on the market, it would secure the payment of the loan that it has provided to the underlying firm. Now, you may think that this example is extreme, that it has no grounds in reality, but it's actually the opposite. We've had major cases on the market whereby we have seen that these conflicts were actually in place, that they did damage the investors very severely. In Italy, for instance, we had two major cases that clearly showed how dangerous these situations can become. One is the Parmalat default, and the other one is the Cirio bond default, which is a little bit older than Parmalat, but where you clearly saw that these conflicts of interest between lending and placement of securities were in place. Now, this is clearly not the only example that you can make, but I will cite other examples of conflicts between investors and clients during today's presentation. But this is the typical citation that you find on manuals when you talk about conflicts of interest arising from the multifunctionality of the MiFID environment. So clearly, you could say that you could handle these conflicts of interest by restricting multifunctionality. And this is an idea that regularly comes up, And after the financial crisis, for instance, in the United States, we saw major reforms and proposals for reforms for splitting up and segregating investment banking on the one side and commercial banking on the other side. So this is a well-known approach. We've had examples in history back in the 1930s and 1940s as well, the Glass-Steagall Act that segregated commercial and investment banking, and then that was dropped, and in some way we are worldwide, people are reconsidering following that approach. In Europe, this approach has not been followed. It has been discussed, but we still think that the financial industry can benefit, and also consumers might benefit from having multifunctional, universal financial players, such as the model of the German Universal Bank. This exacerbates conflicts of interest, obviously, but conflicts of interest can be properly managed in order to enhance investor protection at the same time. And also, if you think about it, even if you were to go back to the old approach that we had before the 1980s, where you had specialized intermediaries that, for instance, could only carry out a single business, such as the old stockbrokers or broker-dealers, as they were at the time present on the London Stock Exchange. This would not really resolve the problem of conflicts of interest, because conflicts of interest may arise even in the context of the provision of a single investment service. Polyfunctionality raises the level of the risk of conflicts, but reducing the capacity of investment firms to one single business does not really solve the problem. But conflicts of interest may also arise between different clients. You can make lots of different examples. One of the most typical situations that you find in literature is where you have an investment firm that provides portfolio management services to different clients. And in portfolio one, the client has a loss, and in portfolio two, the client is gaining money. So at that point, what could happen is that the investment firm that, as you well know, acts on a discretional basis, because portfolio management is discretional, may sell securities from portfolio one to portfolio two at a price which is above market level, so that it sort of covers part of the losses in portfolio one, so that it is okay in some way with the client, who would not complain at that point of having all of those losses or having losses at all. So it would take out some securities from portfolio one and put it in portfolio two on the basis of a transaction which is not properly at market value. And client two would suffer a loss because his the result of the management of his portfolio would be depreciated by the fact that he has received these securities at a price which is above the level of the market. Okay, so that's a typical case of a conflict of interest between different clients that could happen in the context of portfolio management. So the approach that MiFID takes to these topics is based on three different passages. The first is identification of the conflicts. The second is the management of the conflicts. And the third step is the disclosure of the conflict of interest. As you see in this slide, you do not see any indication as to the duty to avoid conflicts of interest or to eliminate conflicts of interest. Conflicts must be identified and then managed and eventually disclosed, which means that conflicts exist. And in fact, on the topic of eliminating at their own roots conflicts of interest, of avoiding conflicts of interest, MiFID has always followed a light touch. And in MiFID 1, there was not even a clear indication, a provision saying that investment firms must avoid conflicts of interest. And this sort of now appears, but very soft, in MiFID 2, which says that as possible, investment firms must try and avoid conflicts of interest. But this is said in quite a timid way. It's a bit shy. It says as far as possible. So it's not really a clear-cut obligation, that of avoiding conflicts of interest, because the stress still is more on the identification and management of conflicts of interest. It's just as if MiFID were saying, okay, guys, we know that conflicts of interests ultimately are inevitable in the investment service world. So what is important is that these conflicts of interest are properly identified and managed so as to reduce the risk of damaging investors and clients of the investment firm. And so actually what happens in the world of investment services and investment services providers is that each firm must carry out a comprehensive exercise of identifying the conflicts of interests. And MiFID provides a broad methodology to do so. For instance, it sort of provides some red flags that you see in these slides. Identification 1, identification 2. These are red flags or signals that in a particular activity, service, or area, there may be a conflict of interest to be considered. But you will not find in MiFID a precise catalog of all the conflicts of interest. You will not even find the two examples that I made. The one of the credit institution providing loans to a corporation and placing on the market the securities issued by that corporation. You wouldn't even find those basic examples because MiFID is based instead on a self-assessment exercise. Each investment firm must look at its own business model, its own strategy, the products and services that it is providing on the market, and carry out a self-assessment of identifying conflicts of interest. Now, this is not to say that this exercise must not be carried out in a very precise and comprehensive way. It's the opposite. It must be provided very carefully and with utmost care by investment firms, because the first duty that you find in MiFID in conflicts of interest is precisely to properly identify these conflicts of interest. So it's not something that people should take lightly. And in fact, we have seen over time in all member states strong enforcement actions by supervisors questioning the way in which this identification process has been carried out. And you have these red flags. MiFID tells you, be careful. For instance, they are not conclusive, but they are significant red flags. So you may have other red flags to consider in your internal organization. The bigger the organization, the more complex the organization is, the more services are being provided, the more red flags you would have to consider eventually. And so complex, big investment banks have truly a comprehensive exercise to carry on. And they have internal compliance departments that are constantly looking for identification of conflicts of interests. And since the world changes, this exercise of identifying conflicts of interest needs to be regularly updated. And I have often been involved as a practitioner in this exercise of identifying the conflicts of interest, and even in small investment firms, it is very complex and needs to be regularly updated. And the red flags that MiFID gives you are just an example. And one of them is, for instance, situations where the firm is likely to make a financial gain at the expense of the client. The credit facility plus placement of securities examples that we saw are fit within this scheme, because in that activity, our investment bank is getting interests out of the loans, and it is also getting a remuneration in the placement of securities on the market. So it is sort of forcing placement of securities at the expense of the clients who get securities which are not in line with their risk profile, and so as to make a financial gain or avoid a financial loss. It is supporting the collection of capital on the market by its borrower, so that the borrower is then in a position to repay the loan on a regular basis. But this is done at the expense of the client ultimately. Okay, and naturally, the second example that I made of switching securities from portfolio A to portfolio B at a price which is not in line with the market value goes directly falls into the second point of this paragraph, where the firm is favoring the interest of one client or one group of clients over the interests of another group of clients. Another example is another red flag is when the firm or a person carries on the same business as the client. And I will now write something on board. Front running falls within this this area. Front running is also a problem of insider trading. We will see front running again when we discuss the market abuse regulation, but it is also a problem of conflicts of interest. I wonder whether you are familiar with this expression or not, front running, but basically, just to sum it up briefly, you have a front running when you provide execution of orders services for your client, and you also act on your own account. Okay, so you are actually placing orders on the market for yourself and for your clients. You are providing the same business as the one which is being carried on by your client. So you at that point you see that one of your clients is sending on the market a big order for certain securities. Suppose that he is buying a huge amount of UniCredit shares, okay? And this order, you are receiving this order and you should place it on the market. And you know that that order may have an impact on the price of the UniCredit shares. It may raise the price of the UniCredit shares. So what you do is you front run your client. And before you place the order of the client on the market, you place an order for your own account, and then you place the order of the client, the price of the security goes up, and you get a profit out of the transaction. So this is clearly a case of conflict of interest. It is also a problem of market abuse and insider trading, but first of all, it is an issue of conflicts of interest. Okay, so before I discuss inducements, I will stop now here, and I leave the floor to the first group, Bernardini, Anzalone, and Rizzello. They will present the Landeskreditbank case, so you can upload your presentation and start once you are ready. Remember, 15 minutes, 16 maximum.
Yes, Professor, can you hear me?
Yes, very well.
So Pasquale should be the one uploading the presentation and beginning with it.
Okay.
Okay, can you hear me?
Yes.
Okay. Perfect. Good morning to everyone. We are Group 9. I'm Pasquale, and today we will discuss about the role of ECB and the allocation of power in banking supervision. In particular, we will talk about the decision of the European Court of Justice in the Landescredit Bank case.
Okay, Pasquale, sorry, if it's not a problem, but if you feel uncomfortable, don't do that. Maybe you can switch on the camera so that at least once during this course, I see your faces, because
it was just for connection, to avoid connection problem, but I can try.
Okay.
Okay.
Okay, good.
This is our agenda. I will guide you through the introduction to the case and through the legal framework, in particular of the banking union. Then with Vittorio, we will talk about the article of the SSM regulation that are relevant for our case. And at the end, Giuseppe, we will go in depth with the Landescredit Bank case and with the argument of the parties. The Landesbank is the main party of the case, and it is an investment and development bank owned by the land of Baden-Württemberg. The case started in 2015 with the ECB decision with which the central bank identified the Landesbank as a significant bank. And with such qualification, the bank goes under the direct supervision of ECB. And so in 2017, the Landesbank appealed to the Court of First Instance because considered its low risk profile, the bank thought that the vigilance of the German authorities would be sufficient to reach the high standard set by the SSM regulation. The request of the bank was rejected firstly by the Court of First Instance and recently by the European Court of Justice. This case is important because allow us to discuss about the several issues that are arising from the new structure of the European supervisory system. We are in the context of the banking union, which is the transfer of responsibility for banking policies from the national to the European level, and it is an important step in order to achieve a better economic and monetary union in Europe. So why is it important to have a banking union? It is important firstly because of the integrity of the euro, and also because of the need of a common supervisor in order to better address the interconnection between credit institutions, and also to replace the home country control principle. It is also important because of the need to break the doom loop between banks and sovereigns. The legal basis of the banking union are in the De Larosière report and in the single rule book. The De Larosière report comes out from the European Commission after the financial crisis of 2008, and it was a political response to the crisis. In fact, the structure of the European system of financial supervisor derives from here because it indicates two levels of supervision, the macroprudential supervision and the microprudential one. While the single rule book is a collection of European laws that govern the financial sector of the entire union. In this slide, we can see the three pillars of the banking union. The first one is the single supervisory mechanism, which is composed by the European Central Bank and the national competent authorities, and has the aim to perform supervision on financial institutions on the euro area. The second one is the single resolutionary mechanism that has the aim to plan, prepare, and resolve significant bank. And finally, we have the EDIS that protect depositors. In particular, the SSM was enacted through the Council Regulation number 1024 of 2013 and conferred to the ECB a leading supervisory role, which is carried out with the cooperation of NCA.
Okay. After having discussed general structure of the banking union, we can now define the role of the European Central Bank within the SSM. Article 4 of the SSM include list of tasks for the ECB. Among them, the ECB, in cooperation with the national competent authority, has to conduct supervisory review, inspection, and investigation, grant all-wide draw banking licenses, assess banks' acquisition and disposal of qualifying holdings, ensure compliance with Euro prudential rules, set higher capital requirement to counter any financial risks. Then, next slide. The general principle for the allocation of powers in the SSM between European Central Bank and national competent authority is the significance of banks. Significant banks are under the direct supervision of the ECB, while less significant banks are subject to the control of the national competent authority in collaboration with the ECB. The article number 6 of the SSM regulation identify criteria to recognize a bank as significant. Among many, there are, for example, that the total value of assets exceeds 30 billion of euro. Indeed, Landesbank assets were above 30 billion. Or that NCA considers the institution significant for the domestic economy, or that the institution is one of the most significant credit institutions of the member state. Then, the main article of the SSM regulation that determine the task and the competencies of the ECB are the Article 4, which, as already seen, sets the task conferred to ECB. And the second one is the Article 6, which sets the criteria of allocation of powers within SSM. In particular, for the task of supervising significant holdings and granting banking licenses, the ECB is responsible for all institutions in the SSM. While for other tasks, we apply the criterion of significance. So ECB is only responsible for significant institution. However, there is a derogation to this provision, which is if particular circumstances apply, a formally significant bank can be treated as a less significant one. These circumstances exist when a direct supervision of the ECB is considered inappropriate. Then, about the timeline, I will underline only the main dates that have marked this case. So on 25th June 2014, ECB informs Landesbank of the classification as significant bank. Then Landesbank requests for the review of the decision, and after the confirmation of the ECB decision, Landesbank brings an action in front of the General Court asking the annulment of the decision. General Court dismisses the bank's action, and then on July 2017, Landesbank appeals the sentence, asking both the annulment of the previous sentence and the annulment of the ECB decision. Lastly, there is the sentence of the European Court of Justice.
Okay, so in this section, we're going to talk about the arguments of the parties and the focal points of this case. So the first one regards the alleged violation by the ECB, of course, from the Landesbank credit point of view, of the principle of proportionality and subsidiarity. The proportionality principle was violated, again, allegedly, because the ECB should have verified whether the NCA supervision would have been sufficient in order to fulfill the objectives of the SSM regulation, while the principle of subsidiarity was instead violated because the ECB, again, from Landesbank point of view, has only supervisory powers on significant institutions, and hence should have demonstrated that the objectives of the SSM regulation were better fulfilled at the union level. On this point, the Court of Justice simply replied by saying that in this case, principles are irrelevant since they can only be applied in absence of an explicit provision by the EU law, and being the ECB exclusively competent in the matters of the SSM regulation, the principles cannot be applied. So the bank's argument was about the interpretation of the SSM regulation, while a more interesting question probably would have been the one regarding the legitimacy of the SSM regulation as a whole, and hence the compatibility of this regulation with the principles of the EU treaties. Now, going on the second argument, is the one regarding the fact that the Landesbank challenged the statement of the Court of First Instance regarding the fact that the ECB has prudential supervisory powers on all credit institutions in the euro area, so including less significant ones. The Court of Justice again replied that as clearly stated in the SSM regulation, the ECB can even issue regulations and guidelines addressed to the NCAs, and in some cases can even deprive them of their direct supervisory powers. For this reason, it is clearly understandable that the ECB has exclusive competencies and powers also in determining the existence of particular circumstances. And this actually marks a shift from a relationship between ECB and the NCAs that was initially based more on collaboration towards a secondary role, a more secondary role of the NCAs in what the court defined the decentralized implementation of the powers of the ECB. Now, the court fails actually to explain the real meaning of this expression, but probably the interpretation that mostly overlaps this decision by the court is the one that differentiates between competencies and powers. Competencies are entirely vested upon the ECB for all credit institutions within the SSM, so also less significant ones, whilst powers are exercised by the ECB for significant banks and by the NCAs in sharing, so together with the ECB for less significant ones. The third point is instead the fact that the Landesbank claimed that actually specific and factual circumstances that made a direct ECB supervision inappropriate in this case actually existed. And the court, on this point, replied by saying that it is not sufficient to prove that the NCAs are equally able to fulfill the objectives of the SSM regulation, but the Landesbank should have instead proved that the NCAs were better able to fulfill the same objectives. And only in that case, the factual and specific circumstances would have existed. But again, the court fails to actually clarify the meaning of this expression, better able, and many questions remain open and unanswered. In particular, how can an NCA be ever better able than the ECB to fulfill the objectives of the SSM regulation when these objectives were built and tailored around the ECB? This actually leaves the ECB with a high level of discretion, especially because if we consider that the tasks, including Article 4 of the SSM regulation, are in a non-exhaustive list, it is very difficult to define the limits and the boundaries of the competences of the ECB. Now, going in the last argument that I wanted to touch on regarding the administrative border review, it is actually a body that is internal to the ECB and that carries out administrative reviews of the ECB's decision. Of course, these reviews can be asked by any entity that is affected by an ECB's decision, in our case, of course, the Landesbank. And this decision by the court actually changed a little bit the DNA and the nature of this board, because it normally issues non-binding opinions. This means that ECB can even ignore potentially the opinions by this board, but the court stated that its opinions should be seen as an integrating part of the statements of reasons of the ECB's decisions, hence implying that although not formally, these opinions are subject to an indirect judicial review, hence opening a further profile regarding instead a publicity system of these kinds of opinions. So in order to conclude, as you have seen, this topic has a lot of implications that go well beyond the limits of this case. And although leaving many questions unanswered, it has helped to clarify some of the points, especially the fact that the exclusive competences of the ECB in the matters listed in the Article 4 of the SSM regulation imply that the ECB is the only entity empowered to actually establish the existence of these particular circumstances. And this, together with the decisions by the courts, marked a shift towards a so-called decentralized implementation of the powers of the ECB, of course, by the national competent authorities, which will hence have a secondary role in the SSM framework. So this is the end of our presentation. And if you have any questions, we'll be happy to answer them. Thank you.
Okay, very good. Thank you. This is a very important case, as you know, and I think you have sort of summed it up properly, highlighting all the various implications. So now let's go back to the topic we were discussing. I will now share again the screen. Okay. So we were discussing the red flags, and as I told you, the case of front running would fall under the first paragraph. Under the second paragraph, we have reference to inducements, and inducements are an interesting topic that we that in some way falls in its own area of MiFID legislations, and on the one side, and on the other side, it falls under conflicts of interest. As to the first topic, its own area of MiFID legislation, there are in fact comprehensive rules on inducements that were introduced first in MiFID I and then have been expanded, as most of the rules in MiFID I have been expanded under MiFID II. Now, inducement may seem as an obscure term. It basically refers to any kind of compensation that an investment firm receives or pays to other parties in the context of providing investment services. And any kind of cost or payment would fall under the inducement provision. Now, some of these costs and payments are effectively necessary for the provision of the service to the client. For instance, in providing an investment service, the investment firm may need to pay transaction costs, commission for the settlement of the transactions, custodians that keep the custody of the client's assets, and then these are perfectly all right. But it may need to pay, it may pay or it may receive payments that may distort the provision of the service. They may create behavioral biases. They may induce the firm to follow a conduct that is not entirely aligned with the interests of the client. One of the most striking examples of inducements that you find in the industry concerns the placement of securities and financial products on the market. When an investment firm places securities on the market, it can be remunerated for its service in two different ways. The first, which is quite uncommon in most European countries, is when the client pays for the service that is being provided. And this is quite uncommon because the prevailing model in most countries, at least, is that the placement of the securities is remunerated by the issuer of the securities. It is the product issuer that remunerates the distribution service. So apparently the client has the impression that he's not really paying anything at all, but he is paying because the payment is embedded in the overall cost of the product, and the distribution activity is in fact remunerated by the product company. Now, we saw last time that under the new cost transparency regime that MiFID II sets out, these embedded costs will have to be disclosed. And they would have to be disclosed also because they would need to be justified in the inducement regulation of MiFID. And MiFID also says that these inducements that the distributor gets must be reasonable and they must be effectively justified because of the service that is being provided by the distributor. Leaving aside the inducements, clearly inducements also raise issues of conflicts of interest. Let me make an example. Suppose that you have a distributor that is placing on the market two products that are more or less equivalent in terms of risk profile, costs, and so on. Think of, for instance, two different investment funds that are more or less the same. But in relation to Fund A, the commission, the distribution commission that the investment firm gets from the producer is higher, whereby it is lower for investment fund B. Now, when it comes to offering those products to its clients, the firm may clearly have a bias in favor of product A vis-à-vis product B. So you may end up with a situation where, for a client, under the suitability test or the appropriateness test, depending on the circumstances, but under those tests, for a single client, it could be that product B is better than product A. But the firm would have a strong incentive to favor product A because of the higher level of inducements that it takes. So you see that inducements pose various issues: transparency, calculation of the overall cost of the service, but they also raise issues of conflicts of interest. In my example, the distribution phase might be biased because of the higher inducements that the investment firm receives for product A vis-à-vis product B. And this is precisely what MiFID would like to avoid. It would like to neutralize the risk of these conflicts of interest impairing the provision or the way in which the service is being provided to the client. So this is another red flag that would be in place, and when in identifying conflicts of interest, investment firms would need to identify and to verify all the inducements that they receive or that they pay, so that their activity is not influenced negatively by conflicts of interest. Once the identification of the conflicts of interest has been carried out, which I repeat is really something comprehensive under the MiFID regime, then MiFID requires investment firms to have in place proper management mechanisms for the conflicts. Let's go back to this slide. So you have three phases: identification, management, and ultimately disclosure. Now, once again, MiFID does not give you a single way or even a detailed list of ways through which conflicts of interest must be managed. It rather sets out an objective and then leaves to the firms the freedom to manage these conflicts in what they think is the most appropriate way to achieve that objective. And the objective is, as you see on the slide, set out by Article 16, paragraph 3 of the directive, which says that investment firms must maintain operational, organizational, and administrative arrangements with a view to prevent conflicts of interest from adversely affecting the interest of its clients. So the ultimate objective is that conflicts must be managed so as to avoid damaging clients, rather affecting the interest, negatively affecting the interest of the client. So that's the objective, and how investment firms achieve that objective is it's basically left up to their own discretionality. We will now, naturally, this discretionality is clearly dependent on the size, the complexity of the business of the investment firm. This is clarified by Level 2 regulation 565 of 2017, which says that these internal instruments and tools for managing conflicts of interest must be appropriate to the size and organization of the firm. So they vary greatly from small investment firms to huge investment banks. these tools for managing conflict of interest have different levels of granularity and complexity. But what is important to point out is that these measures for handling conflicts of interest must be set out in writing. This is very important. They must be formalized. They cannot be left simply to the individual self-assessment. They must be recorded and they must be set out in writing. And they change over time because, as I explained before, the identification of the conflicts is variable over time because of the variability of the business and of the services that are being provided, and also the way through which conflicts are managed changes over time. And you can imagine that therefore in all kinds of investment firms, especially the most complex one, there are internal departments that are almost entirely dedicated to the continuous updating of these processes of identifying and managing conflicts of interest. MiFID II, however, gives you some indications, some hints as to how these conflicts should be effectively managed. This is just a set of examples, and they are not mandatory. They are suggestions, so to say, that the directive sets out, but then it's really up to the self-assessment of the single investment firm to decide which one of these to adopt. And just let me check, because I think that you have a group presentation on conflicts of interest. At least in class 16 there is one, but I see from the list that nobody has picked up. Yes, we'll have a presentation on the 23rd of April, and one group will actually present and discuss in concrete a policy for the management of conflicts of interest. So you will see there an example of how these principles are actually translated into practice. But basically, MiFID gives us some standards to look at, and it tells us that this written policy for the management of conflict of interest is made up of two parts. Part A, which is the identification of the circumstances that may give rise to a conflict of interest. So you will have part one, where you see the identification of the conflict and why the firm feels that there is a conflict in that particular area, service, or product, and then the procedures that are in place in order to prevent or manage such conflicts. This is an interesting part because you see that in this Article 34 of the regulation, reference to preventing conflicts of interest comes up. This is one of the few points where, in the context of MiFID, you have a clear reference to the duty to prevent conflicts of interest. But as I told you, the focus of MiFID is more on the identification and management rather than to an ex-ante overall prevention of conflicts of interest. But you sometimes see that this idea of preventing conflicts of interest comes up, and the regulation refers to this duty of preventing conflicts or avoiding at all conflicts of interest emerges. So there are different sort of ways and techniques and tools that can be used for the proper management of conflicts of interest. And some of the most important, which are effectively evoked by MiFID II as examples, are Chinese walls. Now, Chinese walls is an expression that has now become common standard in this area of investment services legislation. It was first introduced in the 1980s in the UK, together with the Big Bang of the London financial marketplace, triggered by Margaret Thatcher's reform. And Chinese walls is something that clearly brings to your mind the idea of a physical segregation and separation of different functions and responsibilities within an investment firm. And effectively, Chinese walls are most of the times physical barriers that segregate one business, one activity from the other. If you want, we can apply this concept of Chinese walls to the example of the credit institution that on the one side provides credit facilities and on the other side places securities on the market. A way through which you can try to manage this conflict of interest is, well, first of all, you could say we prevent the conflict by not really providing the two services together. But most of the times this is impossible, and huge financial institutions that have a presence all across the marketplace need to integrate these services, and ultimately this may also be positive for the clients. But you need to prevent conflicts of interest. So you can imagine of applying the Chinese walls approach, and by physically segregating the two businesses so that people that place securities on the market are not really aware of what is going on the lending side of the business. And this would mean that the people that work in the two departments are physically segregated. They work in different buildings, or they work in different stores of the same building. They have no access to each other's files. Information is segregated. And this is one possible way to apply Chinese walls. But experience has showed us that these Chinese walls may formally be very strong, but substantially be very weak. You may force people to work in different locations and different departments, but you can't prevent actually the risk that they speak or that they have contacts in any other way, including chats, phones, or simply by going on holiday together, or by attending the same club after working hours. So what you find most of the times is that these physical measures of segregating people through Chinese walls is accompanied by additional measures for handling conflicts of interest. For instance, codes of conduct, segregation of information so that information is not truly accessible to one of the parties, but also look at the second paragraph of this slide, the fact that people who are conflicted are subject to separate supervision and different lines of reporting and systems of control within the single investment firm. So Chinese walls may take out different forms. They may be very formal and turn out to be truly organizational and physical ways of separating people, or they may turn out to be more rules of internal procedure that guarantee an adequate level of autonomy and decision-making power to people involved in different areas of investment services. Now, in the 1980s, when Chinese walls were discovered in the London city at the time, the big surge was towards very strong physical segregation measures. And people really thought that you could eventually touch your Chinese wall, because it ultimately resulted in having people working in different separate structures and places. But today it is much more flexible, and we have understood that that's not always the best way to proceed, and that you should look at substance rather than form. So in some cases, internal procedures might be more effective than physically segregating people in different offices or in different locations. Another very important area where you can apply measures for managing conflicts of interest is remuneration. MiFID tells us that, for instance, there shouldn't be any link between the remuneration of a person which is involved in one activity and the remuneration of a person which is involved in another activity that may raise conflicts of interest. Let's go back to our basic example: credit, lending on the one side, placement of securities. It obviously wouldn't make much sense because of all I have been saying, that you link the remuneration of the people involved in placing securities to the success in recovering the outstanding loan. There shouldn't be any link between the annual bonus or the variable remuneration of people involved in placing securities on the market. There shouldn't be any link in remunerating those people with the probability of recovering the loan in relation to the banking activity which is carried out. So this is just an example, and it goes back to what we were saying. It is important that each line of business is managed according to its own objectives, and always keeping in mind the duty that in investment services you have to protect the interests of the clients and to prevent conflicts of interest from damaging those interests of the ultimate investors. Another measure is to prevent the simultaneous involvement of a relevant person in separate investment services or activities. This is another way through which you can implement the idea of a Chinese wall, instead of sort of putting people in different locations and segregating them in different buildings or in different. So you can simply you can imagine a decision-making process where senior managers are not simultaneously involved in different lines of business, taking different strategic and commercial decisions. And this is part of the internal flow of decision-making process that an investment firm should have, so that it ensures that in a certain decision, people that are involved, senior management, for instance, that is involved in different areas, does not really come up and crosses the borderlines. Now, think, for example, of a CEO of a big investment bank. The CEO is the head of the bank, so he has full visibility on the whole process. How could you manage that? Well, simply you can say that the CEO is the ultimate decision maker. It is the one that receives all the internal lines of reporting, but then the single day-to-day business decisions within the strategy, which is decided upon by the board of directors and the CEO, the single day-to-day business decisions are taken by representatives that have sufficient seniority and that act in an independent way. They always have to report to the CEO, but they are sufficiently autonomous so that they do not receive any influence by the CEO directly that would sort of create issues of conflicts of interest. And then we come to the last part of conflicts of interest management, which is disclosure. And this really stands at the end of the line. Going back to the slide, it's the third step. And it really is the third step even in a practical sense, because MiFID thinks that disclosure is a measure of last resort. It's a measure of last resort. It should not be used as a substitute for the proper identification and management of conflicts of interest. But I will explain this better after the presentation of the case. We'll have 5 minutes to go back to this slide. I want to give you a couple of important information that you should take into consideration. So I leave the floor to the group which is on the Vice case. Thomas, De Arruda, Lucchesi, Destasio, and Baroncelli. The floor is yours. You can upload your presentation.
Okay.
Okay. Do you have issues in uploading the presentation?
It is just downloading it. Just
Okay.
waiting for it.
It's converting it.
Yes,
Yes.
yes, exactly.
Okay. No problem.
Sorry, Professor, are you able to make us all moderators so that we can have access to the slides, or just one person?
You know what? I am unsure how to do that because in the other class it worked automatically. Moderatore. I have to go on preferences, I assume. Because you are unable to upload the presentation. Oh, there it is.
No, I just did it.
Okay, great. Thank you.
I think, Talia, you can just try to
Okay.
change slides. If you succeed in it, we are ready.
Okay, let me just try and see if I can do it myself. Does that change for everyone or just for me?
Yes,
Okay,
yes,
great.
it's working. So we are okay.
Hello, can you hear me?
Yes. Okay, go ahead.
Okay, great. So I'll start my presentation. Good morning. Our presentation will deal with the Vice affair involving the Court of Justice and the German Constitutional Court. So I'll make a brief overview of the context of this case, and my colleagues will further advance with the analysis of the judgment itself. Let's go. So in the EU legal system, the relationship between European and national law has always been challenging. In view of the structure of the Union and the constitutional variety of its member states, complex issues are constantly arising from new legislation. So one of the main points concerns the hierarchy between EU law and national constitutions, particularly when the ultimate guardians of the respective legal orders, the Court of Justice on one side and the national constitutional courts on the other, have conflicting views. Constitutional dialogue between EU courts rely greatly upon the reference for preliminary ruling, which is set forth under Article 267 of the TFEU. And in the context of EU legislation on the role of the ECB, the dialogue between the Court of Justice and national courts is evolving along multiple lines in quite a unique way, especially considering that EU banking legislation is very innovative and only 10 years old. So it's very particular. The main topics for this dialogue revolve around the new legislation governing the financial supervision and banking resolutions, and also the role of the ECB conducting monetary policy. So let me change slides here. As the Vice affair deals specifically with the dialogue between the German court and the Court of Justice, it's important to just briefly overview some of the most relevant of this dialogue. So in the past, the position of the German court was that the acts of EU institutions were outside the sphere of its jurisdictional control. This position changes with the first Solange judgment of 1974. And later, the Solange II judgment affirms that the thesis that while the Court of Justice can guarantee effective protection to the fundamental rights provided by the German constitutions, the German court is not expected to exercise any control over secondary community law. Ultra vires control is later defined for the first time in 1993 with the Maastricht case. In 2009, the Lisbon case introduces the so-called control of identity based on an innovative reading of the German constitution. In Gauweiler, the German court will file a request for preliminary judgment for the first time, so starting to effectively engage in a more serious dialogue using this mechanism. And in Landeskreditbank, as the previous group mentioned, the German court practically inverts one of the findings of the Court of Justice and ratifies its counter limits doctrines in the field of financial regulation. So although the dialogue between the German court and the Court of Justice has always been challenging and tense in some way, there was a clear trend since Solange for a commitment with a pro-EU agenda, which generally led to happy endings. The Vice affair is different and unprecedented because it marks a disruption with this constructive dialogue, and it's quite rude and violent in the way it does that. So when we analyze the Vice judgment, we must look especially to Gauweiler and Landeskreditbank, which raise certain issues that also emerge in Vice. So namely, these are the points that we should keep in mind. These are the discussion of the principle of proportionality vis-a-vis the principle of conferral, the counter limits to EU law set out by national constitutions under the counter limits doctrines, the standard for judicial review of an ECB decision, and the issue of a proper statement of reasons. So this was a brief overview, and I'll leave the floor to Nico, who will start diving further into the Vice case itself.
Okay. Thank you, Thomas. So coming back to the Vice affair, it all started when the European Central Bank launched this public sector purchase program back in 2015, allowing this with this program all the Eurozone national central bank in purchasing the public debt security in order to reduce the deflation risk and keep inflation rate possibly close to 2% target. So contrary to the OMT program related to the Gauweiler case, the previous one, this program has been implemented. But the issue raised by the claimant, leading by the Mr. Henrik Weiss, are similar to the Gauweiler case. The trial started before the BVG, contesting the alleged incompatibility of this ultra vires principle, the attribution principle, and especially the fundamental principle in the German constitution. This is why the German Constitutional Court referred to the European Court of Justice for a preliminary ruling. So the Court of Justice structured its analyses on this program on three main aspects. First of all, stated the duty of the European Central Bank to state the reason on these technical choices, and then specify the nature of this decision, and especially state if these kind of measure, this kind of program are compliant with the alleged article from the Treaty of Function of the European Union that Weiss and the others were complaining on. So the European Court of Justice with the Grand Chamber took this decision on the 11th December of 2018. The court upheld the ECB decision once again, stated first of all that it is considered sufficiently motivated, and in this create maybe the main point of disagreement with the German Constitutional Court that we'll see in a minute, and maybe losing the opportunity to clarify once again, or maybe the judge were too tired probably to specify once again the decisions, technical choices taken by the European Central Bank, assessing that of course these measures fall within the monetary policy nature, and stated once again that addressing proportionality, the European Central Bank has a very broad discretion in adopting these very technical measure, monetary policy, just because this kind of measure is not disproportionate. First of all, because it is limited in volumes and also in duration, and then because it's also not selective. So now let's see how the German Constitutional Court reacts to this preliminary ruling, and I leave the floor to Talia.
Can everyone hear me?
Yes.
Okay, for some reason I can't share my video. I'm not entirely sure why. I'm sorry about this. Okay, so I'll do it without video. I'm sorry. Okay. Thank you, Nico, for that. I'm now going to discuss the Bundesverfassungsgericht ruling. The Bundesverfassungsgericht issued an unprecedented ruling on the European Court's Weiss judgment on May 5th, 2020. In its ruling, it acknowledged that the public sector purchase program did not violate the monetary financing prohibition. However, it stated that the ECB exceeded its competence under the treaties and that the European Court's judgment failed to sufficiently justify that the asset purchase program complied with the principle of proportionality. As a result, the German Constitutional Court declared that the European Court ruling was not binding on the German court. I'm trying to change the slide. There we go. Okay, so the German Constitutional Court's judgment, in a discussion of the merits, reiterates the importance of German constitutional identity. It highlights that Article 23 of the German Basic Law dictates the manner in which German constitutional organs can confer sovereign powers on the European Union, namely in a manner which does not create new competences at the Union level. The European Integration Clause of the Basic Law is based on the right to democratic self-determination, along with the state constitutional principles of sovereignty in conjunction with the so-called Eternity Clause of the Basic Law. Any changes to the treaties of the European Union or unauthorized overreach of Union competences which affect the fundamental rights laid down in the Basic Law shall be inadmissible, as they would affect the identity of the German Constitution. Having underlined these constitutional principles, the judgment moves on to its ultra vires doctrine. An act or measure of a European Union organ is ultra vires if it goes beyond the competences that the member states have transferred to the Union. With regards to the ECB's public sector purchase program, the German court stated that it was an ultra vires act. It goes beyond the European system of central banks' competence of ensuring price stability. Thus, the ruling states, and I quote, "Where a program's monetary policy objective is pursued unconditionally and its economic policy effects are ignored, it manifestly disregards the principle of proportionality enshrined in Article 5 of the Treaty on European Union." So I'll now move on to the German court's arguments against the European Court's assessment of the PSPP. The German Constitutional Court ruled that the European Court of Justice exceeded its judicial mandate according to Article 19 of the TEU in giving an interpretation of the treaties, which in its own very harsh words, is not comprehensible and thus considered arbitrary from an objective perspective. So according to the German court, the European Court's vice ruling was in part ultra vires. The German court asserts that the European Court lets the ESCB do its own review of its program without closer scrutiny and gives the ECB broad discretion in its competences. More importantly, it deemed the European Court's proportionality review to be inadequate. Its interrogation was limited to examining whether there was a manifest error of assessment on the part of the ECB, whether the PSPP manifestly goes beyond what is necessary to achieve its objectives, and whether its disadvantages are manifestly disproportionate to the objectives pursued. In the German court's view, the European Court should have employed a proportionality test which sought to restrict the competences of the European system of central banks and to examine the effects of the PSPP. As a result of this insufficient standard of review, the principle of conferral is undermined and leads to an erosion of member state competences. In conclusion, the German Constitutional Court considered the availability of elements in the European Court's ruling and the ECB's decisions insufficient to assess whether the ECB's initiation of the PSPP was proportionate and compatible with the goals of the treaty and the mandate of the ECB. So I'll now leave the floor to Matteo to discuss the effects of the Bundesverfassungsgericht's ruling.
Thank you, Talia. Straight after the German Constitutional Court rendered its judgment, it has been the object of several discussions and critiques. Many authoritative commenters expressed their concerns regarding the possible consequences of such a ruling, also wondering whether it was an actual legal analysis or whether it also entailed a political economy consideration. In this regard, a widespread opinion began to circulate, according to which, with the vice ruling, the German Constitutional Court intended to send a message both to the European Central Bank and the German federal government. Nevertheless, even though the ECJ ruling was declared not applicable in Germany, the European Union institutions have not been subject to it. Even more, the European Central Bank produced a document manifesting that there was no need to adjust its own policies, and also the German political institutions do not seem inclined to change their support to the ECB policies. Coming to our conclusions, the problem of the vice case, when read in conjunction with other German Constitutional Court precedents, ends up being a procedural question of statement of reasons, particularly related to the incapacity or unwillingness of the ECB to demonstrate that it carried out a proper proportionality assessment when implementing the program. It is therefore not the new or arbitrary in terms of judicial review of the European Central Bank's decisions, since the German court applied the same criteria used in Guaweiler. However, for procedural reasons, the once constructive dialogue led to a tension between national and European Union institutions. Furthermore, a worrying consequences of the ruling stems from the fact that the German Constitutional Court failed to respect its European Union law obligations. Indeed, the repercussions that may come from the decision of not respecting the preliminary ruling issued by the ECJ cannot be underestimated. Not respecting the division of powers between national courts and the ECJ, infringing European Union law, may put into the light the very essence of the relationship between member states and the European Union. The symbolic part of the judgment may have a profound impact in the long run. Indeed, the vice ruling may provide serious damages to the integrity of the Union's legal order as such, risking enhancing a spillover effect that could challenge the very existence of the European Union. If every constitutional court or high court of each member state were to emulate the German example, it would spell the end of the Union as an integrated legal space. This would mean the forever end of the supremacy of EU law, the end of the uniform application of the EU law throughout the member states, and the end of the European Union as a community based on the rule of law, also fatally damaging the single market. Thank you for your attention.
Okay, thank you very much. Great presentations, and always the first day it's the day of the icebreakers, so it's not easy to be in the front line, but you did very well, and I'm very satisfied with both presentations, considering that when I first met you the first day of this course, I had the feeling, maybe it was wrong, that you had no idea whatsoever what we were talking about. The distinction between a directive and a regulation and the treaty was, to say the least, a little bit blurred. That's at least the impression that I got. So to see that you have reached this level of sophistication, and these cases are very complex, is really, on my side, great satisfaction. So congrats. Let's go back to the last 5 minutes of my presentation, and this is again on conflicts of interest and disclosure. So as I was explaining, disclosure is a measure of last resort. By that I mean that MiFID doesn't really like disclosure. It thinks that disclosure should be left only as the ultimate remedy for managing conflicts of interest. And the reason for this is that even under general contract law in all member states, you see that disclosure is a sort of escape as a solution to solving issues of insufficient information, conflicts of interest, weak party protection. And under private law, the concept has most of the times been followed by saying, I tell my counterparty, I disclose to my counterparty, and that's enough. But it's not enough, actually, because in the field of investment services or financial services, the weak party may be in a position not to truly understand the disclosure, its implications. The disclosure may be carried out in a careless way, it may be totally standardized, thereby not providing adequate disclosure to the investor. So disclosure is something that MiFID addresses from two different perspectives. On the one side, if the identification and the management of conflicts of interest is done properly, then the risk of damaging clients is prevented and no disclosure is necessary. So look at the first part of the paragraph. It says when organizational are not sufficient, when organizational arrangements are not sufficient, then disclosure is necessary. So the assumption is that the first two phases, which are essential, have been properly carried out, but nonetheless, there is the risk of damaging clients in the world of conflicts of interest. And for instance, when it comes to inducements, what you can clearly understand is that, let's go back to the example, the two products that have the same characteristics, but one has a level of inducements which is higher than the other, you can reinforce your measures to manage this conflict of interest by saying, I will be particularly careful in carrying out the suitability assessment for these products, because I really want to be sure that if I end up by offering to the client product A, which has a higher level of inducements, I'm not in any way prejudicing his interests. But you may feel that in any case, there is a danger that something goes wrong throughout the process. So at that point, you may feel that disclosure is still necessary. But this is regardless of the fact that you have properly carried out your internal assessment. So that's the first approach. If the internal assessment is truly sufficient and you have done everything that you should have done, disclosure is not required. It is even considered as disturbing, because if you are disclosing a conflict of interest to the client, then this means that something has not been done properly in the first stage of the process. The second way by which you can look at this issue of disclosure is naturally by saying that disclosure is not sufficient to cover deficiencies in the identification and management process. So if that process is deficient, you will not be able to fix it by simply disclosing the conflict of interest. And be it intuitive as it is, I can assure you that I see all the times this issue coming up on the market. Investment firms, credit institutions, not really being in a position to carry out, or they're not willing to carry out, a proper internal assessment to truly apply strong measures for the prevention of conflicts of interest, and then ending up by saying, oh, but we will disclose it to the client. But that's not okay, because if you think about it, disclosure is also something that places the firm in a very weak position, because it is actually a way through which the investment firm is publicly declaring that it is not able to manage conflicts of interest properly. So it's something that sort of turns the perspective the other way around. Instead of functioning as a waiver vis-a-vis the client, it is an admission that something is not working as it should inside the body of the investment firm. So it really is a residual measure that MiFID has kept in place for handling those situations whereby conflicts are properly managed, are properly identified, but there is still a residual risk that clients would be damaged or might be damaged in that particular situation. Okay, but it's a double-edged sword. So you have to consider it in this particular perspective. Okay, so guys, thank you. Just one small request. As I told you, the evaluation of the group presentation is based on the live presentation. So it is also a mixture of what I see, what I hear, and it's not based on the PowerPoint presentation. But once I go back on all the assessments of the group presentations, it might be useful for me just to look at the presentations that I saw and to reattach the presentation to the group so that my memory is sufficiently refreshed. So if you could send me your presentations via email, that would be useful, even though I will not base my assessment on the PowerPoint presentation, but on what I saw during the 15 minutes that you have presented in class. Okay. Okay. So thanks, everybody. Yeah. Talia, go ahead. No problem.
Okay. Great. Okay, now I think my video is finally working. I'm sorry about that. My quick question was just about how, like I read the syllabus in its entirety, and I was wondering if the evaluation is 1/3 for the presentation, 1/3 for the assignment, and 1/3 for the exam, or are they weighted differently?
No, it's 1/3, 1/3, 1/3.
Okay,
It's
great.
just
Thank you
as
very
it
much.
goes. There is no hidden trick in that. It's
Okay.
just as you read it.
Okay, thank you. And sorry for the video issue earlier. Bye now.
That's okay.